afternoon, ladies and gentlemen. Our webinar is beginning, and we appreciate you being with us today. I'm Steve Love, President, CEO of the Dallas-Fort Worth Hospital Council, and we thank you for joining us for this educational webinar today that's hosted in coordination with Hall Renda. Hall Renda, as you know, is a national law firm. Not only are they an associate member of the Hospital Council, they also are a year-round sponsor and participate in many of our events. Today's topic, navigating vaccine reporting and mandate prohibitions from a Texas perspective. We've been looking forward to this presentation, and we are delighted that we've got two national experts that know the requirements, the responsibilities, and candidly, the challenges that are associated with vaccines and vaccine requirements. We all remember during the pandemic when there was a rule that CMS came out related to staff vaccinations, and then in 2023, CMS withdrew some of those vaccine requirements. Some of the states, including Texas, passed statewide laws impacting employers and what they would need to adopt related to vaccine mandates. So there's interplay, if you will, between federal regulations and state regulations. And this certainly will impact not only employers in Texas, but especially hospitals and health systems. Our speakers today that are experts in this area are attorney Robin Sheridan, who's based in Indianapolis, and a person I know many of you will recognize and know very well, Mac Stewart. Mac is based out of the Dallas office. They have decades of experience, and they advise and give legal counsel throughout the United States to hospitals, health systems, physicians, physician offices. Mac, as you know, attends many of our events, and sometimes we get to hear him speak and welcome people, especially at our annual awards luncheon. We really look forward to this presentation. And I want to remind you, if you have questions, please enter them either in the Q&A box or the chat box, and we will try to get through them. If for any reason we don't, we can always answer by email, and we will have a copy of the presentation and PowerPoint available, probably that would be sent out very soon after the webinar. With all that said, it's my privilege to now turn this over to Robin Sheridan. Robin?
Thanks, Steve. And thanks, everyone, for joining us today. And thanks, Mac, for joining us, especially. He and I are going to spend the next hour or so talking with you all about vaccinations of personnel in healthcare from certainly the state perspective, but also some federal perspective and how that needs to be considered given the unique position of Texas. I want to set just a little basis for introduction, and that being our comments today are really focused on hospitals that receive federal funds. So those participating in Medicare and Medicaid. If you have SNFs or childcare or other facilities, different rules likely do apply. And so please be aware that there is a distinction. That said, we are going to start with COVID. We are going to talk about other immunizations and immunizations generally as the presentation proceeds today. But as an initial matter, let's talk about COVID. And Steve gave us a little bit of an introduction on the, as we'll recall, sort of the pandemic approach to vaccinations. And in addition to the CMS requirement, you'll recall that OSHA had an emergency temporary standard that came out in which they wanted all employers with 100 employees or more to require the vaccine. Throughout the course of those few years, OSHA withdrew the ETS, except for some record keeping requirements, which we'll talk about a little later. And then in June of 2023, CMS withdrew the vaccine requirement from the COPs. Notice, though, at that time, while there was no longer a federal requirement that we require the vaccine of personnel, there was no prohibition either. And so most of the clients I worked with kept the COVID vaccination policy in place and continued to require the vaccine as we did influenza and MMR and all the standard vaccinations. But then in February of 24, Texas did its thing, and I will let Mac take it from here.
Thank you, Robin. Good afternoon, everyone. We're honored to be here before you today. Steve, you'll recall that back in May of 2021, you and I did a podcast together on COVID and vaccines. Part of that podcast, we discussed the employer mandates that we thought may or may not be coming down the road. If you go to slide 5, Robin. Back one more, 5. So you and I talked in May of 2021 on the podcast, Steve, and we talked about, for example, we thought OSHA might impose an emergency temporary standard. A lot of places did impose mandates. In those, the heyday of the pandemic, Texas was a bit more open to mandates, but now it's different. COVID is still massively dangerous. The vaccine is still a modern miracle. It is still safe and effective, but the politics have evolved over time, and we're now confronted with these new state laws that are important. If you go to slide 6. So in February of this year, the state enacted Chapter 81D of the Health and Safety Code, which prohibits employers, all employers, including healthcare employers, from adopting or enforcing vaccine mandates. Next slide, please. You can't take an adverse action. Now, as lawyers, when we read the definition of adverse action, any action by an employer that a reasonable person would consider was for the purpose of punishing. That creates a standard that about anyone can decide what is reasonable or not reasonable. So it creates a lot of power for those who want to impose or not impose the mandates, or they can impose the mandates. You take an adverse action for not doing it. So it's a pretty straightforward statute. It says that an employer cannot require a mandate for COVID-19 for employees or contractors, or those who are applying to be employees or contractors. And that's actually creates some difficulty when we consider other aspects of the 89. If you'll turn to 10, please, Robin. They do create an exception. You'll see that may establish a reasonable policy that includes the requirement of personal protective equipment. But the last clause is important, based on the level of risk of the individual presents to patients from routine and direct exposure to patients. Why is that important? They've lifted that directly from the pre-existing regulation that existed in Texas with regard to vaccines. If you go to 11, the pre-existing regulatory obligation in Texas is found in 25 Texas Administrative Code section 1.702. And it is a policy that requires healthcare providers, it's a regulation that requires healthcare providers to create policies to enforce and protect patients from vaccine preventable disease. If we go through this, it requires covered individuals, the policy that these healthcare facilities must enact must require covered individuals to receive vaccines for vaccine preventable diseases. So who's a covered individual? Next page, please. You'll see it's defined, a covered individual is defined as three things: an employee of a healthcare facility, an individual providing direct patient care under contract with the healthcare facility, or someone who's privileged, who may not be an employee or under a contract. So back to 11. So this obligation of hospitals or healthcare facilities, and there's a big long list of who is a healthcare facility, requires this policy be enacted. And this policy applies to those three categories of information, of individuals. But when you turn back to 81D, it says they may, no employer may create a policy, let's say it that way, but it's what it means. They can't create a policy mandating for employees or contractors. So we have two categories of folks under 81D and three categories of folks under 1.702, and they overlap. Both apply to employees and those under contract. So as I started looking at this, you know, I started wondering, what did the legislature actually know that this rule existed in 1.702? And when you look at 1.702, it has that personal protective equipment language that we find in 81D. That's important in terms of statutory construction, because these two rules conflict with each other in some regards. And here's where, as a lawyer who's represented hospitals since 1982, here's the concern I had as I reviewed this. Under 1.702, we can require contractors to get the vaccination. And there are all kinds of contractors in the healthcare industry, but the one I am concerned about with these two rules is the independently privileged physician who also has a professional services agreement with a healthcare facility. And those by definition are independent contractor agreements, because for the most part in Texas, hospitals cannot employ physicians under the corporate practice of medicine. So on one hand, we have 81D, which says you can't force contractors to have a mandate, but 1.701, you can force contractors to have a mandate. So how do we reconcile these things? There are general rules of statutory construction. And as a general rule of statutory construction, the specific trumps the general. And so under 1.702, we have some very specific things, and it is meant for healthcare facilities and those that are employed, contracted, or privileged at healthcare facilities. Healthcare facilities, of course, are also employers. So what do we do? Well, you know, Robin, I'd love to hear what you think about it. I think under 81D, it is so specific as to employers and employees. I think it probably trumps 1.702 as to employees. But I don't think 81D trumps 1.702 with regard to physicians who are providing services under a PSA, but who are independently privileged. And why do I say that? Let's apply some logic here. The legislature knew that 1.702 existed. They could very well have legislated completely around 1.702. 1.702 clearly recognizes that you will have physician contractors at a facility, and they need to be vaccinated at the facility. 81D is so broad that I don't think it is meant to apply to contracted physicians at a healthcare facility. Now, I'm going to strongly suggest to those of you who are listening today, you go talk to your legal counsel about this, because that's just one person's application of general rules of statutory construction. But as I review this, I think that under the state 81D, hospitals cannot force non-privileged employees to have a mandate, to have the vaccine. If they are privileged, typically they're privileged as an allied, as either a physician or allied health professional. AHPs may not be employed, and they can't be privileged. So I would argue that if you have someone, even if they're under a contract, PSA, who are privileged at a healthcare facility, 1.702 allows you to develop the policies that you need to have. Now, what are those policies? You must have a policy that requires they receive vaccines from basically whatever the facility thinks is best from the CDC list of vaccines for preventable diseases in the healthcare environment. And they have a big long list, and I printed it off and now I've managed to replace it. But it includes COVID, it includes RSV, which of course is a new vaccine we're seeing a lot of in adults. It includes the flu, measles, mumps, all those sorts of things. So you have a policy. What happens next? Well, they have to decide which ones they're going to do, which ones they're going to adopt. And then the next question becomes, how do we know they did this? I have clients that go both ways. I have some clients that say, all we want is an attestation from the healthcare provider saying, I got the vaccines, and don't require proof otherwise. Other hospitals require specific proof. My personal opinion is that hospitals should require specific proof. Now, of course, under 1.702 and 81D, they do carve out that you can require the use of personal protective equipment. And it has to be tied to whatever the circumstance is involving those particular practitioners. But some interesting things have occurred over the year with 1.702, because there are religious and good, moral exceptions to that. I've had a number of folks try to get exceptions. Some with arguing a religious exception based upon an incorrect belief that fetal cells may have been used in the mRNA vaccines, which of course are the Moderna and the Pfizer vaccine. Over time, we've learned that fetal cells were not used, so we stopped adopting or accepting that kind of religious exemption. Others have suggested that their particular religion doesn't allow it. You spend a little time with that, understanding the tenets of that religion, and that's not the case. So when you ask someone for an exemption, or when someone asks for exemption, our advice is spend a little time looking behind what the point of the exemption is. We've had other folks that simply say, I don't want the government to tell me what to do. I understand it. It's Texas. I get it fully. But the government did allow us to tell them what to do. And in the past, when we've had physicians that refuse to get vaccines, which are mandated by the facility, we simply say, then you can't treat patients. They don't like it, but I do think the law gives us that right. So what takeaway do I want you to have from these two rules, these two statutes? Well, in all likelihood, employers and healthcare facilities cannot require non-privileged employees to take the vaccine. But understand, 81D only applies to COVID. It doesn't apply to all the other vaccines. So under 1.702, I think you had a list of them on the next page, or 2 pages down, Robin. And here are some of the ones. The list is probably 20 or 25 long, but flu, MMR, varicella is measles, isn't it? Hep B, COVID-19. Under 1.07, you can require all these others to be taken. You can mandate it for non-employed, non-contractual providers, and I think you can apply it to all employees for everything but COVID. Probably not on COVID, but again, I suggest that you address you talk to your in-house legal counsel and see what their position is on it. I think I'm, as a lawyer and who enjoys this kind of stuff, it's going to be curious to see if anyone attacks this in the courthouse. Tries to say 81D says you don't have to make me do it. 1.07 says I have to do it. You're going to have to court resolve those. And that's when we begin at the statutory construction. And I believe, in my opinion, general rules of statutory construction will allow 1.701 to trump. So if there are any pertinent questions on these issues, I'd be glad to answer them now. We can answer them later. And then I think, Robin, you're going to kind of talk about more of the federal aspects of it, including some ADA issues.
Okay. Okay, so not seeing any questions. We'll move on to some of the federal expectations. And I say expectations because from a federal perspective, most of this, what is necessary to meet the COPs comes from CDC recommendations. And so just sort of putting it in perspective from Mac's presentation, we know that the state of Texas requires that we have a policy that requires vaccinations of all personnel except for COVID, and that the question that Mac raised in terms of particularly independent medical staff members and whether or not they're covered by the prohibition. But we know we need a policy, and we know the policy needs to be different from our the pandemic policy, right? And even from the influenza and MMR standard policies that we probably had historically, because we have that adverse employment action provision in the new law that kind of dictates an individualized approach. And it's not incredibly unlike the accommodation requirements that we have under Title VII and under state fair employment law for disabled and religion. But let's think about policy and perspective to CMS first. So CMS reporting expectations. Even though CMS pulled the condition of participation requiring that personnel have the COVID vaccine, they did not pull the COVID vaccination rate reporting requirement. So under the inpatient quality reporting program, we still have to report. We have to report 1 week of data every quarter. The reporting is fairly draconian. In other words, if you miss your quarter reporting, you lose the, what do they call it? Like the market basket update, I think, for that quarter. And it doesn't matter why. Generally, appeals have been unsuccessful in this area, even when clients' computers have crashed on the last day of the quarter and they couldn't get the reporting in, or the person responsible for that was on an emergency medical leave, and so the data wasn't available, and they tried to report late. CMS really drives a hard line on this. So to keep your reimbursement in full under the program, you need to report 1 week of data quarterly. All of you that are reporting already, you probably know very well. You've got the COVID reporting and you've got the influenza reporting. With respect to the COVID reporting, which we're focusing on today, there's a number of categories of personnel that you need to report, and it's fairly complex. So one thing to think about is, in light of the prohibition on the vaccine mandate, a lot of employees get in their head that you can't ask me anything about COVID. Well, that just isn't true. Nothing prohibits us from collecting the data, and in fact, CMS requires that we collect the data. We are not judged on vaccination rate. So in other words, our reimbursement is not impacted by the percentage of those that are vaccinated, but instead on our the completeness of our reporting and the timeliness of our reporting. So to the extent you are modifying policies to be compliant with this new prohibition, we need to still keep in mind that somehow in intake and maybe at annual compliance training, we get updates for vaccination rates so that we keep that data whole and we keep gathering it in a form in which we can use it to report. The conditions of participation require policy. And so the policy of the infection control program itself sort of overlaps with the human resources policy of how do we gather information at intake, like at orientation, and move that into our system. How do we update it? I meant to mention back here that CDC implies that you need proof of this vaccination vaccination, but CMS does not require that you submit proof of the vaccination. So it's somewhat an administrative risk determination. I will tell you that I'm not aware of anyone on survey being asked for the proof, but certainly given what Mac raised with the requirements of documentation on the state side, you all in Texas are probably in a somewhat unique situation on being able to gather that documentation, keep it for your state compliance, but then also have it for your CMS survey.
Could I offer a comment at this point?
Absolutely.
I think it's very wise. What you said is very wise because it may not be mandatory on a federal level, or it may be mandatory on a federal level to say we want affirmative proof, but it's not mandatory on the state level unless you choose in your policy to make it mandatory that you show me the proof. And I would argue that with those who, your physicians, and they'll be there, who say, well, I just want an attestation. You say, well, we're going to need it because of federal law. Always blame the federal law. Sorry, I'll be quiet now.
Oh, no, absolutely not. So thinking more about the policy and what our policies include, you'll notice the infection control policy or the infection control standard references a requirement that your program adhere to nationally recognized infection prevention and control guidelines. That's essentially the CDC recommendations. So we'll see repeatedly throughout the presentation today references to those CDC recommendations. So the state raised them in the what you should require of vaccinations that Mac just talked about. Here we see it in the infection prevention and control COP, and we're going to see it again from OSHA in just a few minutes. And so we go back to the CDC for what is recommended. Notice that guidance is pending and will be updated in a future release. So that's the current interpretive guidance on the infection prevention and control standard. So keep your eyes open. We're going to get more direction from CMS on this issue in the near future. If you haven't seen it, there's an infection control worksheet out there. Now, I will tell you, I think it's odd. It's dated. It's from 2015. It has not been updated since then. To some degree, it makes sense because after 2015, we had the pandemic, all the rules were put in place and waivers were put in place for the pandemic, and then the rules were withdrawn and the waivers went away. And so we are kind of back to pre-pandemic considerations. So perhaps that's why the 2015 infection control worksheet is still being shared by CMS. But I think it's interesting when you look at the infection control worksheet, and I realize the slide makes it teeny tiny, so you will see it in the PDF that the council will share. It includes in the survey Hep B vaccinations, MMRs, varicella, Tdap. But here at the bottom, if you look at that yellow box, you'll see there's no citation risk. There's no tag. because the COPs don't technically require particular vaccinations. And to some degree, they can't because of the accommodation duty that we'll talk about in a minute. There will be personnel who will be exempt because of religious reasons, because of medical reasons. And so we interpret this page of the infection control worksheet to be the guide that demonstrates compliance. So in other words, if you answer yes to all these questions, you have demonstrated compliance with that portion of the infection control standard. If you cannot answer yes to all of them, you're still not cited, but you may have to be able to explain how your infection control policy protects the workplace, exercises the surveillance that's required, sort of the standards that are captured. Okay. As we move into ethical considerations, I wanted to jump back, and Mac, feel free to jump in if you want. There recently was a request of the state for guidance on incentive or educational materials on the COVID vaccine. And the state responded by saying, no, you cannot promote the COVID vaccine. I think the context of this was even to pregnant women. And they came down very hard on the idea of promotion of the vaccine being contrary to the spirit of the state law. With the requirement from the state that employees get all these other vaccinations, and with the requirement from the COPs that you gather the COVID information and that you have the infection control policy that essentially requires other vaccinations, it makes me think about workplace incentives and how do we are required to offer the influenza vaccine as part of the infection control standard. We are required by infection control and by the state law to develop this policy that requires all these other vaccinations and to keep our workplace safe for coworkers, for patients, for visitors. So how do we incentivize vaccination to those who are hesitant? We can impose a requirement, although we know we can't do COVID as a condition of employment for especially employees and contractors. So can we incentivize them to get the COVID vaccine to help us meet these other general standards? Given the state's response on promotion of COVID vaccines to the agencies, I think we have to be very, very careful. I don't think we can promote the COVID vaccine to employees and contractors as we might otherwise. We can offer it for free. We can offer it on site and conveniently, but I think we have to be very careful that we don't have it as part of like a wellness program or some other, human resources, health plan related incentive program that is promoting the vaccine. And so as we talk about all that, the question sometimes becomes like, so how does, do no harm fit into all of this? And we pulled some of the AMA opinions that obviously encourage physicians, right, to be vaccinated and to accept immunization both for themselves and their patients and their colleagues and to support it. But it stands somewhat at issue with COVID in the state of Texas. So we would encourage you to sort of to consider this, but to also consider other elements of your workplace that might have to have a second look given the new prohibition, your code of conduct. If you have, sometimes we have like goals of the organization and things like that. So policy from human resources, policy for infection control, and these other sort of compliance with the law and codes of conduct may also need another look given the state prohibition. Mac, did you have anything you wanted to add with that?
Well, as one who litigated for 40 years, that word promote causes me some angst. It's such a wishy-washy word. I want to know, when can something be promotion and when is it not? Because I can argue given an incentive as a promotion, but I can also argue just as easily, no, it's just, you know, you want to have it, we're going to make it easy for you. You don't have to do it. I just think we need to be, probably we need to create policies that within the healthcare facility that talks about promotion. I think we're going to have to do that.
Yeah. Okay, and kind of on that same vein, wanted to make sure you were aware that HHS issued the new conscious rules just in March of this year. These are really nothing new. They call it a new rule, but this is a reaffirmation of the Church amendments, the Weldon Amendment. There's a laundry list of historical amendments that have given healthcare personnel the right to participate in or to refrain from participating in procedures based on religious or moral grounds. The new rules are really administrative. They talk about sort of the protocol for complaints and how the agencies are handling them. There is a posting requirement, though, that comes with the rule as well. So you'll want to make sure that your postings are updated to reference the new rule. We are not seeing an influx in claims. We thought we might see when HHS sort of brought this to the attention of the public again, but it may be early. For the most part, the church rules focus on abortion, contraception, and sterilization, but we have seen challenges in assisted suicide, and we expect challenges in gender-affirming care. So be sure your postings are updated, and be sure your accommodation policy contemplates not just religion and disability, but also conscious objections. And then, fortunately or unfortunately, the issues around vaccination pull in so many considerations that it really takes a moment, I think, to get your arms around of the places in the organization that this might impact and that we should look at. And so in Texas, you have a safe workplace regulation. Not unlike other states, it's essentially a duty to provide a safe workplace. We sometimes see infection control rules challenged under workplace regulations. The other place we see workplace regulation come up probably more frequently is in retaliation. So an employer who is requiring compliance with the policy or an employee who refuses to comply with the policy or who raises concerns about safety and then has some adverse employment action. Quite honestly, sometimes when it's totally unrelated to the safe workplace regulation, but nonetheless, we see retaliation claims under safe workplace. And so wanted to simply raise this for your attention because we do see it raised in infection control perspectives. Oops, OSHA has a number of implications for vaccination policy. So as I mentioned earlier, OSHA pulled that emergency temporary standard that required us to require vaccination of COVID-19. They pulled that actually earlier than CMS pulled the COP, but they left the record-keeping requirement in place. And that is that a incident of COVID in the workplace, if it's determined to be work-related, needs to be on your OSHA 300 log. And there's some standards that makes it a recordable illness. It's similar to other the standard for other recordable cases. So it has to be a confirmed case of COVID-19. It's got to be work-related, and we all know that's sort of a question and unto itself. And then it has to require medical treatment beyond first aid, days away from work, the kind of things that we always look at as to whether a work-related incident is recordable or not. But just know that even though the requirement for vaccination left, the record keeping for incidents of COVID is still part of OSHA. OSHA's bloodborne pathogen also addresses vaccination, and it requires the Hep B vaccine and vaccination series to employees who have occupational exposure. I don't think this is anything new for anyone, but it is another place in the federal guidance where vaccinations are contemplated.
Robin, I think we've got about 10 more minutes because I do have some questions people sent me earlier that we could go into, but kind of 10 more minutes.
Okay, I will tie up quickly then, just to call so folks know what information is in here, and then we'll turn it back to you, Steve, for questions. Very quickly on otherwise on OSHA, the general duty clause requires you keep a safe workplace. We have seen infection control issues raised under the duty clause, and here OSHA specifically said we think you have to require the TB vaccine, and that the failure to do it would be a violation of the general duty clause. Joint Commission, for those of you who are accredited, requires that you offer influenza, but it also requires that you report vaccination rate of influenza annually to a host of stakeholders, organizational leaders, physicians, other licensed practitioner staff, and your board. So work that into at least your annual compliance report for your Joint Commission standard compliance. As we kind of mentioned earlier, duty of reasonable accommodation underlies a lot of this. Whether or not we will require compliance with any policy is always subject to our duty to accommodate disability and sincerely held religious belief. I wanted to let you know that a United States Supreme Court case very recently increased our burden to show undue hardship. So we used to have a de minimis burden for religion, but for disability, we had to show like undue harm, or we had to show a higher level of harm to refuse to or to deny an accommodation for disability. We have that same standard for religious beliefs now. It's a higher standard, and so if your accommodation policy references the old de minimis standard for accommodating religion, you're going to want to change that. And that's back to you, Steve.
Okay, thank you. Great presentation. In the chat and the Q&A, we don't have a lot of questions, but I had some people that are going to listen to the recording, and they sent me questions previously that they wanted asked, and they dovetail nicely with your presentation. Question number one, and this may go back to what Mac said, it's going to be fun to watch this play out in the courthouse. The question was, when you have a conflict between state law and federal law or federal guidance from CMS, which prevails?
Mac, you want to start?
Oh, yeah, there's a good one. So first of all, state law and federal guidance is guidance, the law is law, so you follow the law. When there is a conflict, it's a risk management issue. If I decide that I'm going to follow a state law that doesn't follow the federal reg or rule, what's going to happen to me? And I presume the question is that CMS requires something or doesn't require something. It also depends on what that conflict is. If the conflict is it's mandated at state, mandated at federal, then you can state law and you won't be violative of the federal law. If it's mandated at the federal level, you have a risk of losing some of your funding, so you have a cost-benefit analysis under those circumstances.
And I would just add you'll want to look at what you think is the conflict really carefully, because as Mac highlighted earlier, sometimes the definition of these terms is such that at the end of the day, there really isn't a conflict, or it's a much narrower conflict than you may have first glance thought. And so to work very closely with your counsel to really evaluate the extent of the conflict, if there is one.
And there are tools available to us with those conflict. We could seek Texas Attorney General opinion. What's your opinion on whether or not federal law trumps state law or vice versa? And they can issue opinions on that.
Right. The other question, I was at a meeting in Austin, and this was brought up to me by a contractor who's not in the DFW area, but he had heard about having this horrendous discussion. His company pulls cable to really take the cable and connect it to devices within businesses. And he had a contract to actually pull cable in a hospital, I think in the Houston area. And the cable was going to be pulled through the ceiling, but it was going to be over the ICU and it was going to be over the OR. And the hospital requested that the people be vaccinated that pulled that cable because of the close proximity to the patients. And they said, their attorney said, well, if they were masked, they could do it. And I said, well, I can't answer that, and I'm not an attorney. But in y'all's opinion, if you have contractors that are like physicians or nurses that we just talked about, that's one thing. But what about incidental contact as indicated by that question? Any thoughts on that?
In my mind, 81D addresses that directly. You can't require health contractors of any sort to get a COVID vaccine. The distinction between 81D and 1.702, of course, is 1.702 applies to healthcare facilities, and it applies. The covered entities are those who provide care and treatment and are involved in patient care. So I would suggest that they can ask all day long, but they can't require it under 81D of non-healthcare provider
For the COVID vaccine.
the COVID vaccine.
For
Yeah.
the COVID, okay.
Yeah, for the other vaccines, I think it's a matter of statute, and I would have to look at that closer, which I don't have in front of me at the moment. But is it directed at healthcare personnel? Like sometimes our obligations arise for those who have direct patient care, in which case those folks would not. But also as a matter of policy. I mean, other than for COVID, the hospital has the ability to write in its sometimes you call it the vendor policy or the outside contractor policy, that they require vaccines of anybody who steps foot in the organization because they want those folks. They know they're going to be in the cafeteria having lunch beside the nurses, and that they're going to be, taking their break, in a lobby area where patient visitors are. And so oftentimes the hospital policy will require vaccination of its contractors as a matter of policy. And other than for COVID, I think they can do that.
To follow up on that, another question. Excuse me, Mac, go ahead.
If you have contractors, vendors come in, and they are the type that you're going to have a contract with, as opposed to just, pull cable, send me an invoice. You can build that into your contracts too. Then it becomes a matter of contract, except for COVID.
Okay, and I think you've answered the question they asked on contract nurses. I guess on contract nurses, you could build a contract, but you couldn't require they have COVID vaccine. Is that correct?
That's where the rubber hits the road on these two statutes. If a nurse is contracted but not privileged, I would argue that you can't force the COVID vaccine. But if they are contracted and they're in an area where they also secure privileges, the prime example are CRNAs or nurse practitioners who come in and cover things, as well as physicians under a PSA. I would suggest there is a very reasonable argument that I would not be embarrassed to make that you can require them to have the COVID vaccine if they indeed are being privileged to provide care. Nurses typically are not privileged to provide care. And the 1.07 says A covered individual is one to whom has granted privileges to provide direct patient care. And I do a lot of medical staff work, and to me, privileges means they go through the credentialing process. I could make an argument that, I'm going to hire you as a nurse. You're licensed, you have the right, the privilege to take care of patients. You can make that argument. It would be a hard argument if they're not granted specific privileges.
Right. Mac, you pointed out under Texas law, generally you don't employ docs. There are some instances where you can employ docs. Can you require an employed physician to get the vaccination?
Well, there's the rub again, because under 81D, employer-employee, that's what it is. Under 1.07, it's it says an employee of a healthcare facility. So on one hand, you say, I can't force an employee. On the other one, you say, I have to have a policy that tells them. That's where I go to statutory construction and say, again, the specific trumps the general, and I caution everyone to go get legal advice on this. But I think there's a reasonable argument that any contracted healthcare provider or any employed healthcare provider that otherwise meets the definition of a covered individual under 1.702 can be required to get the COVID.
And Robin, this question is probably more for you from a labor point of view. You did a great job saying, we know you can't mandate in certain cases the vaccination, but you do have an obligation to gather as accurate data as possible for reporting purposes. What if you ask an employee questions about COVID and they simply refuse to answer and say it's none of your business, and you don't want to be accused of retaliation? What would be your advice?
Another risk-benefit situation, but I think to the extent that the employer makes clear and documents, of course, the discussions that makes clear is we're not requiring the vaccine. Our documentation is clear that we're simply asking if you've had it, what you had. If you didn't have it, you check a different box and set it in. There's no, it's not tied to wages. It's not tied to hours. It's not tied to benefits. It's simply one of those many pieces of paper you fill out in new hire orientation, where you give your home address and your birth date and your tax information, and you give your vaccination history for COVID. I think to the extent a new employee refuses to answer those questions, you would take the same approach you would take if they refuse to give you their home address, or they refuse to, complete the W-2 form.
Right.
Something else that I would caution, this has happened to me. I've had clients who, in particular, infectious disease practices, who required their employees to get vaccinated back when they could before this 81D. And people would bring in vaccine cards that were clearly counterfeit. It happened more than once. So I would caution that if you ask that question, oh yeah, here's my card, take a look at it, make sure it's not counterfeit if you can.
Good point. The final question, this person had done some research, Robin. I think they may have looked at your presentation, just kidding, ahead of time, but they said, we know there's further pending guidance coming out from CMS. And I think Mac may have answered this. What if it conflicts with state law? And I think I heard Mac say guidance versus law is different than law versus law. So when the guidance comes out, if it does conflict, it's going to be, as Mac says, you need to go talk to your legal counsel and kind of walk through that, I guess. Is that the right answer?
I think so, because the guidance, I think what they're talking about is the additional guidance in the interpretive guidance for the COPs. And right. So we don't expect a change in the condition of participation itself, but that infection control COP is really vague. I mean, it says, you have to have policy that contemplates, keeping infections out of your workplace, right? Out of your facility. So to the extent that the guidance calls and gets specific and doesn't say, base it on the needs of your facility, but instead says you have to require COVID vaccines, then, I mean, as Max said earlier, a number of attorneys are going to have to escalate this to the Attorney General or otherwise, and probably to CMS as well, to get clarification on risk.
Could I make a comment on the word guidance too? There are a couple of different kinds of guidance, like you go to the interpretive guidelines, so the conditions of participations, guidance. Well, it's telling you this is how we're going to interpret it. So understand that. So it's guidance on how you need to read it. Others are, well, we're going to suggest you do this, but you don't have to do it. So when you think about guidance, you need to think about it in those two contexts.
Excellent points. I don't see any questions in the chat and Q&A, and I think I've covered all the questions people email me prior to this presentation. So Robin and Mac, do you have any closing thoughts before we end the webinar?
No, just thank you very much. And certainly you have our contact information. I know Chris is going to share the PDF of the PowerPoint to anyone who would like it. Don't hesitate to drop us an email if you have follow-up questions.
As always, it's a delight to work with the council. I know of no other organization in the country that provides this kind of content to its people. And so congratulations yet again, Steve.
Thank you so much. And Robin and Mac, and on behalf of all the people that are signed on and participating, we thank you. Excellent presentation, excellent answer to the questions. And this will conclude the webinar, and we hope everyone has a safe and restful rest of the day. Thank you very much.
Take care.
Thank you.